Hello, ladies and gentlemen. Welcome to this Supreme Court case overview video. In this video, we'll be tackling two cases that at first might not seem so related. Those cases are Gideon versus Wainwright and Roe versus Wade. As I've tried to get you to think about with this picture here, the big idea that these cases have in common is the evolution of civil liberties. Yes, we understand in a broad sense what our civil liberties are. Things like the freedom of expression, things like the freedom to exercise our religion. And there are those that are defined and debated in the Constitution, but what about those that have grown, expanded, and evolved over time? Both of these cases, which are required for the APUS Gov curriculum, deal with those sorts of liberties that have evolved over time. Now, the key questions in these cases really reveal that. There might be a phrase in the Constitution like the right to the assistance of counsel, which of course means the right to an attorney. But what does the right to an attorney mean if you can't afford an attorney? Is that right different based on how much money you have? Does this mean merely the right to purchase an attorney, for instance? Is that maybe even a bit odd of a thing to include then? Or maybe when we think of something very fundamental like the right to privacy, well, does it matter that the Fourth Amendment talks at length about how the government can't search your stuff, but the words right to privacy never occur in the Fourth Amendment, in the Third Amendment, in the 14th Amendment? Does that matter that those words never show up? You see, the Bill of Rights is a short document. You could read through it in 5 minutes. And the result is that there's plenty left out when it comes to fully understanding what our civil liberties are, and they were always going to evolve over time. And we're looking at two close cases that illustrate just that. The first case, 1963 case of Gideon versus Wainwright. Clarence Gideon, who was a man in Florida, he was charged with breaking and entering, but he was never appointed a lawyer. Now, Gideon could not afford a lawyer. He asked for one from the state of Florida, and the state of Florida said you only are provided with a lawyer if you're accused of something that could end up with the death penalty. Breaking and entering could not end up getting you the death penalty, so Clarence Gideon could not be provided a lawyer. He would have to pay for one if he wanted it. But the Supreme Court ruled that this was unconstitutional, that the Sixth Amendment's right to counsel, right to an attorney, is not just a right, it's a guarantee of that right for all defendants. Regardless of what you're being accused of, if you're being brought into a criminal court, the government must be willing to provide an attorney for you if you cannot afford one. And that's a pretty significant expansion. A classic example of an evolution. The Constitution says one thing, right to counsel. The Supreme Court expands that right through a court case like Gideon versus Wainwright. In many ways, as controversial as it is, the 1973 case of Roe versus Wade is much in the same vein. Now, understand for the AP test, you must understand Roe versus Wade. You are not required to agree or disagree or defend or refute the ruling in Roe versus Wade. We all know that abortion can be a very controversial topic. They are not necessarily looking for you to argue a specific side of this, but they do want you to understand the importance. And the importance of this case, as you'll see, is actually very similar to Gideon versus Wainwright. In 1973, a Texas law made abortion illegal in all cases. Actually, the only way to get an approved abortion in the state of Texas was if your doctor said it was absolutely necessary as a life-saving procedure. And this caused quite a big ruffle. You see, just a few years before, the Supreme Court had ruled that the right to privacy does exist in the Constitution. And Jane Roe, who, interestingly enough, for privacy's sake, did not use her real name, argued at the Supreme Court that this violated her right to privacy. The government did not have business involving itself in a procedure, a medical procedure like an abortion. And the Supreme Court agreed. They agreed that the Texas law, which made abortion illegal in all cases, was unconstitutional. What you're really going to be expected to know for the AP test is why, and that's because of the 14th Amendment's due process clause. They said, we've already ruled on this, that yes, the 14th Amendment's due process clause includes the right to privacy, and this includes early on decisions about abortion. Now, notice that little caveat there. The Supreme Court ruled that as a pregnancy gets closer and closer to being completed, and then eventually we have a child, the Supreme Court ruled that as the pregnancy goes on, that then the right of the unborn child or fetus, whichever you prefer, it starts to grow a little bit compared to the rights of the woman. However, in the early stages of the pregnancy, where irrefutably, what is developing in the mother's womb could not survive outside of the mother, very clearly that, whatever we want to call it, whether again it's an unborn child, a fetus, it does not necessarily get the same rights that the woman has. And that means that this decision is between a woman and her doctor because of the 14th Amendment's due process clause in the early stages of a pregnancy. Now, what this did was it expanded the right to privacy. It expanded the right to privacy. Now, when you look at this idea of the right to privacy, as I mentioned, it was ruled on previously. What does the right to privacy really mean? Well, the right to privacy is very simple. It's the idea that you have the right to be left alone by the government. And so in this case, the Supreme Court ruled that if you're getting an abortion early on in a pregnancy, the government has to leave you alone with that. Now, there's an interesting way of looking at both of these cases, which we have of that these have expanded certain civil liberties, certain rights for individuals, and that is as a product of history. In fact, if you've been following these Supreme Court cases closely, you might notice some commonalities with respect to dates, and that's that they all happened within a very short time frame of the 1960s and 1970s. This is an era you could definitely be asked about on the AP test, known as the Warren Court, when Chief Justice Earl Warren sat on the Supreme Court starting in 1950 and just about up to 1968-69 term. Now, Earl Warren was the former governor of California and came in to make a lot of very progressive reforms to how our rights were interpreted. Right off the bat, he had some big cases, but it really picked up in the 60s, the Warren Court, in particular with cases we've looked at, like the 1962 case of Engel versus Vitale or Baker versus Carr, right? Both of these cases completely changing what people thought of as acceptable. No prayer led by teachers in public schools, and Baker versus Carr, obviously that one person, one vote idea. Moving on, you have plenty of rulings from the Warren Court about the rights of criminal defendants. App versus Ohio, that Fourth Amendment ruling about the exclusionary rule. And Miranda versus Arizona, the Miranda rights you're familiar with. Now, you don't need to know those two cases, but as we talked about, Gideon versus Wainwright also happened in this era. Moving on, the Warren Court was the ones who passed down Griswold versus Connecticut, which I alluded to a moment ago, which said, yes, the right to privacy exists in the Constitution. This laid the foundation for what we just talked about, Roe versus Wade. And it doesn't stop there. They also issued in the Warren Court some very big rulings that we've studied about First Amendment rights, like Tinker versus Des Moines, free speech of students, or 1971 case of Wisconsin versus Yoder. That was the Amish free exercise clause case. So you could definitely be expected to know this on the AP test. Not all of these cases, those in gray, are not required for the curriculum. However, you could be asked about how the Warren Court used the power of the Supreme Court to expand civil liberties, and all of these cases serve as examples. There are plenty of ways to apply these cases as well. First of all, with Gideon versus Wainwright, excuse me, Gideon versus Wainwright, the Supreme Court expanded the rights of defendants throughout the 1960s. I showed you some other examples of those cases with Mapp and Miranda. And secondly, the Supreme Court has wrestled with this abortion decision ever since. As I mentioned, it was a very controversial ruling, but when you look at it, controversial rulings are not always final at the Supreme Court. Many people have argued that this ruling should be overturned. Many other cases have arisen asking what restrictions can be placed on abortions. And well, if you see those cases, you might see that the Supreme Court really has flip-flopped, not on ever if abortion can be banned in all cases. They've said no, but so what restrictions can be placed on it and what sort of things are constitutional there. Folks, thank you for tuning in. I know this was a bit longer of a video, but we want to get that idea of the evolution of civil liberties down, Gideon versus Wainwright, Roe versus Wade, and the role of the Warren Court in all of that. I hope you're walking away with a little bit better understanding of that. Best of luck and have a great rest of your day.